So today I want to talk about how to process invention disclosures within your business, whether they're produced by you as inventions or whether your employees are inventing. What do you do with those inventions? How do you decide best what to do with them? We're going to talk about that in this video. So let's say that in your business you have employees. You might be coming up with inventions. Your employees might be coming up with inventions. Now, hopefully you have some kind of an internal process for gathering up invention disclosures, and that may be the subject of another video. But for now, I'm going to assume that you have some way to extract inventions from your employees through some type of invention disclosure process. That can be having them record inventions in a notebook that they have, recording them in some online system, in some kind of a form, and we'll talk about that more, as I said, in a future video. But when you get these invention disclosures, you have to make a decision and assign each one of them a disposition, or at least that would be a best practice for you to be doing. Assigning a disposition to inventions developed by yourself or by your employees within the confines of your business would be a best practice for intellectual property portfolio development. When you have an invention disclosed to you by one of your employees or something that you came up with yourself, there are three main possible dispositions you can assign to that invention. Either decide to file a patent application on it, maintain it as a trade secret, or publish a defensive publication that discusses the details of the invention. Now, defensive publication is something that I haven't talked about before, and so I'm going to focus a lot of attention to defensive publications in this discussion. Now, deciding on whether to maintain something as a trade secret is a process in itself. In fact, each one of these steps is a process in itself. Trade secret protection is determined by the law of your state or by using the federal trade secret protection that's available, and that protection is different than patents. For a little bit more information about deciding between filing a patent application or maintaining something as a trade secret, see my video on trade secrets and how to decide here. When deciding between whether to file a patent application or maintain something as a trade secret, one of the main aspects of the invention you need to determine is what I call its detectability, and I'm going to talk about that a little bit here. I'm not sure how well you can see this, hopefully you can, but this is a flowchart I came up with to kind of help the decision process and whether to file a patent application, publish defensively, or maintain a trade secret. So you start with your invention disclosure, you take a look at it, and you make a decision on whether you think that there would be some patentable subject matter. Now, that analysis is complex in itself, and I have other discussions that you can take a look at about patentability, but basically you decide, is it novel, is it non-obvious, and if you think those criteria are met, well, then you have patentability. If you're sure you have patentability, the next thing you look at is it detectable? Now, rather than saying yes or no on detectability, I'm showing that as high and low, and it might be more like medium high, medium low, because you have to make a judgment call on what the level of detectability is for the specific invention. But let's look at it from the standpoint of high and low. So if it's low detectability, then you can maybe maintain it as a trade secret rather than filing a patent application. Likewise, if you decide it's not patentable subject matter, and you know it's not patentable, well then there's no harm in maintaining it as a trade secret. You're not going to get a patent on it. You might as well maintain it as a trade secret. If the detectability is high, on the other hand, and you're patentable, then filing a patent application would make sense. But let's look at the situation where patentability is unclear. What if you really don't know? You think there might be something patentable there, but it's really unclear, probably not patentable, probably it would get an obviousness rejection, and the obviousness rejection would be strong. In that case, what should you do? Well, then I would say, look at the patentability from the standpoint of a probability. And if you think the probability of getting patent claims allowed is maybe greater than or equal to 50%. And again, this is a judgment call. These are just, random percentages that I'm putting in there. But let's say that, greater than 50%, greater than half, you think, okay, I probably could get patentable claims. Then maybe you go ahead and file a patent application because the patentability is unclear, but you think there's a chance greater than not that you might get a patent allowed. So filing a patent application in that case is okay. But if you really think patentability is very slim, it's less than a 50% chance you're going to be able to get patent claims allowed, then we can think about defensive publication. Now, what does that mean? Defensive publication means that you're creating prior art. So you're basically taking your invention and you're making your invention prior art. Now, why would you want to do that? The reason you want to do that is because although you're unclear whether you can get a patent allowed on it, and you don't want to spend the money and the resources to file the patent application, because filing patent applications and prosecuting them through their allowance is an expensive process. So you don't want to expend the resources to do that. But on the other hand, you don't want somebody else to do it, because if somebody else did it, then they might be able to use that patent against you. Now, the patent may be undetectable, it may be unenforceable, but it doesn't mean that they can't use it to harass you in litigation and cause you a problem. And you don't want somebody to stop you from operating, to stop you from producing your product. And so in the interest of maintaining your freedom to operate, your freedom to produce your product without fear of somebody attacking you with a patent for an invention that you developed but decided you didn't want to spend the money on the patent, you file a publication, you file a white paper, some kind of publication that puts the invention and how it works and how it's made into the public domain so that it's now prior art. Now, here's one interesting point. You can create a defensive publication also by filing a patent application. The patent application, once you file it in the United States, it gets published after 18 months. So although it's expensive to produce a patent application, and it's expensive to pay the filing fees for a patent application, the patent application gets published after 18 months. So the patent application does serve a couple of purposes. One is you might get the claims allowed, in which case you have a patent. But even if you don't get the claims allowed, the published application at least becomes prior art, which blocks somebody else from getting a patent on that subject matter later. So you don't have to go through the patent office to get a patent application published in order to have a defensive publication. You can publish, for example, on IEEE or some other publishing venue that allows you to publish a technical paper and put all the information about your invention into that technical paper. But if you file a patent application, that is another way to get a defensive publication. So one thing you can do is maybe you get somebody to do the patent application at a lower cost. Somehow you negotiate a lower cost price. So for example, maybe you can get this specific patent application done at a lower cost because you're not sure yet whether you want to actually prosecute it, and maybe you'll wait to get an office action and see how strong that office action is to decide whether you want to keep going forward with it or not. But at least you'll know you'll have the published application, and that can serve as prior art whether you decide to continue with the prosecution of the application or not. And if it turns out that the office action is something you can argue against, you may get a patent after all, even though you were unclear about the patentability at this step. So defensive publication, it's a tool that you can use to create prior art to prevent somebody else from getting a patent on an invention that you have that you don't want to be patented and enforced against you and your business. I hope you found the information in this video helpful. If you did, please like and subscribe. That helps me a lot. And if you know anybody else that might be interested in this information, please share the video with them. That also helps. That's all I have for today, so see you in the next video and stay inventive.